Hello, my name is Joseph Greenwell. My pronouns are he, him, and his, and I serve as the Vice President for Student Affairs and University Life at Columbia University. Welcome to this webinar on Title IX 2.0, Understanding Changes to Title IX and Columbia's Policies. Before we start, I'd like to give gratitude. I'd like to give gratitude to each of you for being here today on this important topic. I'd like to give gratitude to our panelists. So that is LaShawn and Margie and Kevin, who are going to share their expertise with us. And I'd like to give gratitude to Jody and Nina, who made all this happen with doing all the logistics for this event. Thank you so much. At University Life, we focus a great deal on community citizenship, and that's what this is all about. Sexual respect is core to our values and imperative to create a community of inclusion and belonging at Columbia and beyond. Today, we will learn about new federal regulations and how the university responds to incidents. However, I want to remind everyone here that sexual respect is our collective responsibility and that it starts with prevention. It's on all of us to create a safe and inclusive environment at Columbia. This includes educating ourselves. So thank you for being here today. This includes stepping in when we see a friend or someone else that needs help and support in a time of distress. This means also having these important conversations with your friends and family members and colleagues, to name a few. Like I said, we'll be hearing from our panelists who are experts in the field, but this is truly a partnership for the entire community to work together. Thank you again. Thank you so much for all that you do to create a campus climate based on sexual respect, both inside and outside of the classroom, whether it be online or in person, and no matter where we may be physically located across the globe. Thank you. So with no further ado, I would like to now ask our panelists to introduce themselves and to start the conversation.
Good afternoon, everyone. I'm Marjory Fisher, and I am the university's Title IX coordinator. And as such, I oversee cases including sexual harassment, sexual assault, dating violence, domestic violence, and stalking. I have been here for 4 years, since 2016. And before that, I was a consultant doing investigations across the country on these important cases at all sorts of colleges, universities, and K through 12 schools. Before that, though, I spent the bulk of my career, 30 years, as a New York City sex crimes prosecutor. I was the chief of the Special Victims Bureau in the Queens DA's office for 23 years. So thank you again for coming. I echo all of Joseph's words about the importance of prevention. And I'm glad to be here today, and thank you all for being here. And I'll turn it over to Kevin.
Thanks, Margie. I'm really excited to be here. I just wanted to echo Joseph's statements about all of us coming together in this space to talk about a very important issue. My name is Kevin Pitt. I'm Associate Vice President for Student Conduct and Community Standards. I've been at Columbia, I'm new to the Columbia family, so I've been here for about a year now, and I lead a fantastic team, the Student Conduct Community Standards. Been working in higher education for about 15 years, primarily in the student conduct space and Title IX space. Before Columbia, I was at Rutgers University in New Brunswick, overseeing the Office of Student Conduct, where we did Title IX adjudication and student conduct adjudication. Before that, I was at the University of Pennsylvania doing similar student conduct and Title IX work. And I spent a large, before University of Pennsylvania, I was at the University of Maryland, College Park, where I did student conduct, housing, and Greek life work as well. So I have a lot of experience working with students in these spaces and during these challenging times, and here to support. And we look forward to educating today. I'd like to turn it over to LaShawn.
Good afternoon, everyone. My name is LaShawn Rivera. I'm the Executive Director of Sexual Violence Response. I've been with Columbia University now for 11 years and doing anti-violence work around sexual violence, intimate partner violence, and the prevention and education of these issues for over 16 years, specifically in higher education. I'm glad to be here this afternoon and looking forward to the conversation.
Great. LaShawn, can you share with us a little bit about SVR and, how to process the material today if, it's difficult to think about?
Yeah, so first I'll start with sexual violence response is 24/7 year round. So we are never closed. So you can always reach an SVR advocate at any point if you need to speak, if you're dealing with a crisis, any type of immediate assistance that you might require. In those interactions, our advocates are also available to support with accompaniment services. So in the event someone is needing someone to accompany them to the hospital, to assist them with making a report, whether it be on campus or through law enforcement or other officials, your advocate is there for you. And so they can walk you through that process. They can meet you at those specific locations and really make sure that they're there for emotional support, explanation of rights and options, and also to ensure your safety and process throughout that. In this conversation, we are going to be discussing issues that may be difficult for some participants to listen to, may be difficult for participants to really think about. And for some of us, we may have experiences with these issues, whether it be supporting someone in our lives who have dealt with sexual violence, intimate partner violence, some form of gender-based misconduct, or maybe ourselves, we've engaged with these issues in some shape or form. So it's really important that you take care of yourselves as we discuss the content and the information and the policies. What that might look like can be very different for everyone. If you need to take a break, step away for a moment, please do so, drink water. And if you would like to talk to an advocate, throughout this conversation, the number is on the screen, 212-854-HELP. 4357. So like I said, that's 24/7. At any point, you would reach a direct advocate with the sexual violence response team who's ready to support you. In addition to our advocacy services, we do a lot of prevention and education. This month is October, which is Relationship Violence Awareness Month. And some of you may have participated and joined us for some of the events we've hosted throughout October. So with that, we also do additional educational programs. So if you're interested in learning more about how to prevent, how to advance and improve your skills as a bystander, or if you're just interested in discussing the issues, please contact our office. You can request a workshop or a tailored workshop by visiting Columbia Health website and check out all the workshops that Sexual Violence Response has available.
Thank you so much, LaShawn. Jody, can we go to the next slide? And if anyone has any questions, feel free to type them into Q&A and we will address those towards the end of our program. So in order to talk about Title IX, I'm going to tell you a little bit about what it is and how it came to be and how things have changed to get us to where we are today. So I'm going to give you a little history lesson. On June 23rd, 1972, Title IX was enacted as a follow-up to the passage of the Civil Rights Act of 1964, which I'm sure most of you know was passed to end discrimination in various fields based on race, color, religion, sex, or national origin in the areas of employment and public accommodations. However, the Civil Rights Act did not cover those who participate in educational programs or activities receiving federal financial assistance. Thus, this was a follow-up to the Civil Rights Act, and it was enacted to prohibit discrimination based upon sex in all federally funded educational programs. As you can see this picture here, this is many women who participated in getting this important law passed, and President Nixon, who signed the law into effect back in 1972. So I'm sure some of you are thinking, my, how things have changed. So what did Title IX address? Well, at the beginning, as you can see here, Title IX on June 23rd, 1972, was on the cover of Sports Illustrated. And if we were in person, I would say, why is that? And you can see the language of Title IX here. It's short enough to be in a tweet. No person in the US shall, on the basis of sex, be excluded from participation in or be denied the benefits of or be subjected to discrimination under any educational program or activity receiving federal financial assistance. And it all started out with sports. And really, Title IX was used at that time to address the huge gender inequity that existed between men's and women's sports in the day. I like to say when I went to college back then, back in what I call the Mesozoic era, if I went and said, I'm a soccer star from Ohio, I want to be on your women's soccer team. And they said to me, we don't have a women's soccer team, we just have a men's team. They would have to either create a women's team or put me on the men's team. And this was an incredibly impactful law. Today, more women in some Olympics are winning golds than men, and commentators put that squarely to the credit of Title IX. And this picture says it all. Between the year Title IX was passed in '72 and the first Women's World Cup in 1991, the sport saw a 17,000% increase in US girls playing on high school soccer teams. And that's a fabulous shot. I just love it. And that's why I put it here. But it really illustrates the impact that Title IX had. But things changed over the years, and in the early 2000s, through the Obama administration, Jody, you can go to the next slide, the implementation of Title IX's scope widened tremendously, and the law was utilized to address other acts of discrimination based on sex that occurred in educational institutions. And what it did was those acts caused a loss of educational opportunities due to sexual harassment, which people began to realize included not only harassment, but sexual assault. People started doing surveys at research institutions, and they found that 1 in 4 or 5 women, 1 in 12 men were saying that they were experiencing non-consensual sexual contact and sexual harassment during their college years. And so when President Obama took office, eyes were focused on these statistics that were extremely alarming, as you would agree. And he created the President's Task Force on Campus Sexual Assault on January 22nd, 2014. And this effort was designed to change the culture on college campuses and to stop blaming victims and to make sure that people, as Joseph said earlier, stepped up when they saw this unfolding. And instead of saying it's none of my business, they said this is our business, and they reached out to help. And that was the goal of the Obama administration's efforts in this field. You can go to the next slide. In 2011, a letter was sent containing guidance to colleges and universities, which they by and large followed, even though it wasn't law, it was guidance. And they wrote a letter called a Dear Colleague letter, and they said, you are required, university receiving federal funding, to have policies prohibiting certain behaviors. And it required that colleges and universities do their best to ensure a harassment-free environment. The federal government took a much more aggressive role when it saw these statistics that I mentioned and the effect that it was having on students who experienced this in their educational experience. And this is the key. They said when a school knows or reasonably should know of possible sexual violence, it must take immediate and appropriate steps to investigate and conduct a prompt, thorough, fair, and impartial and equitable investigation. And if the investigation revealed a hostile environment, the school must then take prompt and effective steps reasonably calculated to end the sexual violence. So this was strong language. And the hammer over the heads of institutions receiving federal funding is if they did not comply, they could lose their federal funding, which could be millions to billions of dollars a year. Well, what was to come? That guidance was withdrawn in 2017, and I'm sure you understand why. One of Donald Trump's campaign promises in 2016 was memorialized in the Republican platform at the time. And it stated that colleges and universities should not have a prominent role in the resolution of these cases, and that the federal government should have no role in micromanaging colleges' response to these cases. They wanted the rules to change, and it was part of Trump's platform. And he then appointed Betsy DeVos as his education secretary. You can go to the next slide. And as you can see, they made good on their promise. And on May 6th, 2020, right slam in the middle of the pandemic, Betsy DeVos, after receiving 125,000 comments or near to that on her new regulations, making the definition of Title IX far narrower in terms of what cases colleges must respond to, posted the rules and said, "You're not doing anything else during the pandemic. You must be in compliance with these rules as of August 14th, 2020. Thus, every college and university in the country that received federal funding had to rewrite the rules for their university, for their institution, changing the rules of adjudication. And these rules not only narrowed the scope of the definition of what constituted a Title IX case, it also changed the rules of how they would be adjudicated. And these could be considered the most significant and lasting legacy of DeVos's tenure as the education secretary of this country. You can go to the next slide. A lot of people say to me, well, will these new rules, who many consider a huge change, people worry that this will chill, people students who want to make a report. Will this be forever? There have been several litigation challenges to these rules, but so far, none of these cases have really made any progress towards undoing these rules. In fact, motions for a preliminary injunction, in other words, a stop to these rules, have failed. A lot rides on the election. Joe Biden, who, as I said, spearheaded these efforts for the federal government, when these rules were posted, vowed a quick end to the DeVos sexual misconduct rules. However, it might take a period of time to do that should he become the president. You can go to the next slide. The courts are probably unlikely to find that the DeVos rules are what are called arbitrary and capricious. Those lawsuits may not go anywhere. And the Biden administration, should there be one, could seek to roll back these regulations through a Congressional Review Act vote in Congress. But it's challenging, and they would have to control Congress in order to do that. And it is estimated that if they have to post the rules like the Trump administration did, get notice and comment, that it could take up to 2 years to undo these should this happen. Meanwhile, the rules are the rules, and they are the law, and any college receiving federal funding must obey them. So what has changed as a result of these new regulations? You can go to the next slide. What changed and what remained the same? Let's see. Well, what is the new definition of harassment under Title IX? The new definition of sexual harassment is as follows. Prior guidance told colleges and universities that they should investigate any unwelcome conduct of a sexual nature. Now, the bar is far higher. Schools must, or lower, depending on how you look at it. Now, schools must only respond to sexual harassment as defined in the regulations as follows. It only includes, number one, quid pro quo sexual harassment. After the last year, maybe some of you know what this is. That's Latin for this, for that. And that is a promise of some kind of educational or employment benefit in exchange for a sexual favor. Quid pro quo. Number 2, it includes unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the institution's educational program or activity. And number 3, sexual assault, dating violence, domestic violence, and stalking. So in other words, this new rule requires the behavior to be much, much worse to trigger a university response and harder to prove, as you will see. Title IX cases now cover only behavior that occurs in a university program or activity. You can go to the next slide, Jody. And activities that occur in the United States. If you remember, the language I showed you of Title IX said in the United States. So the DeVos rules go back to the original language of Title IX. So next slide, Kevin, can you share with us, for a case to be considered a Title IX case that has occurred in an educational program or activity, what does that mean?
Thanks, Margie. So now, as you just explained, we have 2 shoots. We have the federal government has now dictated to universities where these events can happen. So defining where these events happen, program or activity. Title IX, that shoot, it has to occur on campus. And think residence hall, think a classroom on campus. Now we have a gender-based misconduct shoot at Colombia as well, 2 distinct shoots that if an activity or a violation alleged that a violation occurs off campus, that could be GBM as well. There is kind of a cutout for residents or buildings that are run by student organizations. So think about a fraternity house and an incident that may occur there. What's also important for the purposes of this policy is that active alum are defined as a graduate student of the Columbia's undergraduate or graduate degree granting program or a non-certificate program, right? So not only where events happen, the federal government has now defined who can follow these charges as well. So if they're participating, alumni is defined now. So alumni are participating in one of Columbia's specific alumni groups, or a person who's graduated from Columbia's degree granting program. So it's important to remember the federal government has now defined who and where.
Okay, great. So yes, it's, a complainant, that's a person who makes an accusation, a person who says they've been harmed and they're a student at the university. That's easy, as Kevin said. They are definitely covered by Title IX if it happens on campus. A respondent must be a student at the university or an active alum. So it restricts not only the place where it occurred, it also restricts who can make a complaint and who can and where the incident happened. So what triggers the initiation of a process in the interim Title IX policy? It's a report filed by someone. It could be a report filed by a mandatory reporter, and that is a person who is student-facing employee who learns of a case of sexual assault, dating violence, sexual harassment, and so on. They must make a report to the university. A complainant, someone who's harmed, can make a report. A friend of a complainant, it could be anonymous. But ultimately, the complainant has the right to move forward or not, no matter who has made the complaint. But the formal initiation of the complaint, you can go to the next slide, Jody. The formal initiation, and keep going, sorry. The formal initiation of a complaint in the interim Title IX policy has to be after whoever has made the report. The complainant has to either send an email or sign a paper or something indicating that it is from them to formalize the process beginning. If the complainant does not want to, and the university decides, that would be the Title IX coordinator, me, and people in student conduct, that it should go forward regardless, because we have other evidence, because there's a risk to the community, I, as the Title IX coordinator, can sign a formal complaint. You can go to the next slide. So some of you may have heard that one of the major changes in the way the Title IX cases, the ones that go through the Title IX chute, as Kevin says, require a full hearing to adjudicate such a case. What does that mean, a full hearing? It means that it's got to be a setting where witnesses come and speak about what they know, where the parties speak and are questioned by the other side's advisor. It's more akin to what a courtroom looks like, but it's not a courtroom. It's a live hearing with someone who presides over it, called a hearing panel chair. We can go to the next slide to talk about what that means. Kevin, can you describe what kind of questioning goes on? It's characterized as cross-examination in these Title IX chute hearings.
Right, so they use the term cross-examinations and the definitions that the federal government issued to universities, but that's just a fancy term for questioning. We want to demystify this for you. When you hear the term cross-examination, you may think about Law and Order or what you may have seen in popular culture, but this is not that. What we mean by cross-examination is simple questions in an effort to seek the truth for both sides, the complainant and the respondent. So what's important to remember is that you will be asked questions. These are questions that you know the answers to because these are your experiences. So being able to walk through what happened that the night in question, or the alleged night in question, you know, when, where, who, all these things will be asked of you and everyone else who participates. That means witnesses, complainants, and respondents. You may have a concern, well, when I hear cross-examination, I think something that's antagonistic. That's not the environment we seek to create. We want to support all parties involved. And we have a hearing chair that's there to moderate in terms of relevance and any evidence that's submitted, and decorum. So what we mean by decorum is basically the emotional temperature of the room. So we want to ensure that all parties are taken care of, both sides, and that there's no leaning in on complainants or respondents. There's no aggressive questioning, there's no yelling, there's no cursing or screaming. We want to create an environment that's professional and that's supportive for all parties involved. So we have decorum, rules of decorum that are outlined in the policy. I encourage you to read those if you do participate in a hearing, but they really set the parameters for the truth to be sought and for the hearing to go smoothly.
That's terrific. Thank you so much, Kevin. You can go to the next slide. So Kevin, can you describe what happens? Let's say I participate in an investigation. I meet with the investigators once or twice. A report is generated. I've shared evidence with the investigators, and I come to the hearing. I tell my story, but I don't want to submit to cross-examination. Under the new DeVos rules, what happens to all of this evidence that I've supplied if I don't want to submit to this kind of questioning?
Well, Margie, this is a great question. We understand that going through a Title IX hearing can be very challenging, emotional for both sides, and we want to be supportive of that. And oftentimes students may decide to say, you know what, this is too much for me, I want to remove myself, and we understand that. Unfortunately, under the new regulations, anything that was submitted by that complainant or respondent, that means text messages, pictures, anything else will not be considered, right? No negative inference is made, right, for the hearing chair. But that evidence, anything that was submitted before or after, will not be considered by the panel.
Thank you, Kevin. LaShawn, can you describe how SVR could help out with this part of the process, which, you know, in some cases can be just questions that a complainant or a respondent could answer and really not not have a challenging time, but some people, it could be very challenging. Could you tell us what SVR can do to help?
Yeah, so I mean, I would even say SVR could, help a little bit earlier. So prior to an individual getting to this part of the process, a lot of the work that advocates do with individuals who, I'll use the term survivors. I understand in this process it's complainant, but a lot of time is spent in preparing for what this process is going to be, what the hearing might look like, what questions do they want to submit. So doing what we call just taking time to do some of that preparation and prediction in the process to ensure that they, are prepared for what might come up, if they're going to need breaks, what are going to be their coping mechanisms throughout that process, and also the day of, what is that going to look like? And I know we'll talk about this later, but being in a virtual setting and how can the SVR advocate support them throughout, even in those moments. So yes, certainly at the time in the moment of questions, they can ask to take a break. Their advocate, if it's a physical location, will be waiting, outside of the space where they're doing the virtual hearing, be able to sit with them, talk with them. If they need a cup of coffee, tea, snack, water, whatever that emotional support is going to look like, and it works for that individual, that's the way an advocate can be present. In addition to that, it's really important for some people to have a plan for once they've gone through this process, the day of, what types of situations do they need to have in place. So maybe they're working with a trauma specialist from Counseling and Psychological Services in Colombia Health. So the advocate may be helping coordinate through the student, with the student's permission, to have an appointment or a check-in with their clinician and CPS, so that anything that might come up after the questioning and after that point of the process, that they have that support system in place and lined up. So there's a variety of activities of how an advocate can support. It's always discussed and agreed upon between the advocate and the individual that they're supporting. And a lot of that work happens prior to even getting to this phase of the process, because the advocate wants to make sure that they've communicated with colleagues and partners, and ensured that the student has what they need. So those are just some of the activities that I can, offer as
Thank you.
potential options.
Thank you so much, LaShawn. That's so helpful. And I would say that one thing that's really important to know also is not only is there hearing panel chair to make sure that everybody is treated respectfully in this process, witnesses, respondents, complainants, but the respondent and the complainant will be in two different places. So if we're virtual, they will be, entering the virtual hearing room at different times. They can meet with their advisors in a breakout room. They could even meet with an SVR advocate in a breakout room. And so they will not be sitting face to face as one would imagine in a Law and Order Special Victims courtroom. Just wanted to mention that. One final change that's been made is that employees are now covered under these rules as well. So if a student made a complaint about an employee, harassment, sexual harassment complaint, for example, and it fit in the definition of Title IX that I've described to you, they too will be entitled to have a hearing. Go to the next slide. So, in light of all of these new rules, what did Colombia choose to do about their responsibility to address these non-Title IX cases? Because after all, the regulations shouted out to universities and colleges across the country, this is the minimum. This is all you have to do if you want to just address this very narrow chute of cases. But if you want to address other cases, you can. And so we've created a gender-based misconduct policy as well to address the cases that are not addressed in the definition of Title IX. So we've made that choice. And the cases that require the hearings that Kevin just described with the cross-examination fall squarely in the Title IX definition and the Title IX chute. In the other policy that will be responsible for governing and addressing the adjudication of everything else, those will not have such an expansive hearing. So we're still addressing cases not covered by the new definition of Title IX. Why? Because we believe that because these regs do not cover all of the types of misconduct or the places where it could happen, that Colombia as an institution still must address them. We want to, be in keeping with our own commitments to an environment of sexual respect, free from gender-based misconduct, and our obligations under New York state law. There's a law called Enough is Enough, which governs campus sexual assault cases in every New York State institution, and New York City law as well. So we have these two policies. We can go to the next slide, Jody. And the next. So we have these two policies. We can go to the next slide. We have the gender-based misconduct policy and the interim Title IX policy. And Colombia's Title IX policy. Let's see, hold on. Jody, can you go back to one? Under the interim Title IX policy and the gender-based misconduct policy, the university remains committed to diligently investigating reports of misconduct, supporting students and others who experience gender-based misconduct, and responding fairly and firmly when students violate university policy. Okay, we can go to the next slide. Kevin, can you describe what an investigation would look like under the gender-based misconduct policy and what the hearing after it would look like? We've described a hearing under the interim Title IX policy. Can you describe what this would look like under the gender-based misconduct policy?
Thanks, Margie. Sure. So what's important to remember is that our office, the Student Conduct and Community Standards Office, we partner with Margie, General Counsel, SVR, other partners on campus, and make sure that these hearings are done well. And we've been doing the gender-based misconduct format hearings for a long time in this process. So basically kind of a boilerplate version of what we do is that we have an investigation, right? An investigation, what we mean by that is asking questions, trying to seek the truth, trying to seek facts of what allegedly happened during, with regards to the allegations. So how do we do that? We have interviews with suggested witnesses. The complainant, the respondent may suggest witnesses and other people for us to talk to. We talk to those individuals. Excuse me, we make a report compiling everything that was learned after we've collected evidence. And that could be text messages, direct messages on social media platforms. Our investigators, a lot of them are former attorneys who are really skilled at working with students in a higher education setting. So they're sensitive to these issues. They understand the modern communication methods, and they're able to collect this evidence, compile a timeline, collect and summarize witness statements to make a story, to tell a story that is compelling and that really kind of addresses the allegations. From there, any question that one party has for another is asked during their investigation. So we solicit those and we ask that during the course of the investigation. Now, what's different than what I just described earlier regarding the Title IX hearing is that there's no cross-examinations, right? In the hearing process, your advisor can be there, but they're not cross-examining or anything like that, the other party. All questions are coming from the panel, and they're just seeking to clarify the investigation report. So these hearings are often a little bit faster than what a Title IX hearing would take in terms of a day. But the gender-based misconduct process is really driven by the panel. They're asking questions of both sides, complainant and respondent, to clarify what was in the investigation report. At that point, a decision is rendered. They'll write a statement, opinion, basically outlining what was decided and what the rationale was behind that decision. And then there's options for appeal. So that's kind of the boilerplate version of how the GBM process works. And again, we've been doing that for many years.
Great, thank you, Kevin. Next slide. So with all of this information, what remains the same? We still have mandatory reporting here at Columbia, which I described to you earlier. And we still have the right of any party to not participate should they not wish to. Now, of course, in the Title IX cases, if you don't submit to cross-examination, your story really can't be considered by the hearing panel chair. But if there's other evidence, there may be a way to make a case, but it's challenging. But regardless of that, any student has the right not to participate. Off-campus conduct, as Kevin just described, is still covered under the gender-based misconduct policy, and study abroad conduct is still covered. Supportive measures like moving somebody if they're living on the same floor with the person that is accusing them or is accused. Academic accommodations. You know, I suffered from intimate partner violence this weekend, and I had to go to the hospital, and I can't take that test tomorrow. No contact directives between the two parties. These can all be provided whether or not a student files a complaint. The standard of proof is the same, and that's called preponderance of the evidence. You know, in a courtroom, you have beyond a reasonable doubt. This is a little less evidence required to find that someone is responsible for violating Colombia's policy. What does it mean? Preponderance of the evidence means if I'm the investigator, I find that it is more likely than not that it happened. The Trump administration said, you can make a requirement for even more evidence called clear and convincing evidence. We did not opt for that higher standard of proof. As Kevin said, the right of appeal is still available to both parties, and informal resolutions can still be offered instead of an investigation. Attorney advisors are provided free of charge for the parties in these cases, and that has not changed in both the gender-based misconduct policy cases and the interim Title IX policies in these cases. So when one goes to file a complaint and formally initiates it, they will be given the right to have an advisor. If they don't want that advisor and they want their coach or their friend to be the advisor, it doesn't have to be an attorney, and they can choose that, or they can choose to have an attorney advisor, which is provided by Columbia free of charge. Can you go to the informal resolution slide, Jody? Next one. So informal resolution is an option for a student to choose instead of going through an investigation and a hearing. Kevin, can you describe what does it mean to have an informal resolution?
Yeah, thank you, Margie. So really quickly, informal resolution is a term that some of you may or may not have heard before. It basically has three pillars, and universities call them different things. But here at Columbia, we have mediation, training, and restorative justice. Mediation is exactly what you've heard in popular culture in terms of getting two parties together, talking through what are some options to make this situation right, and how do we come to a consensus with regards to, I believe I've been wronged. I believe there was a violation that has taken place here. How can we resolve this through mediation, coming to consensus? Training, exactly what that sounds. The university offers a wide variety of trainings. Margie does fantastic trainings with students, faculty, and staff. But there's also other resources on campus. If there's sexual harassment, there's sexual harassment training. There's other trainings that people can sign up for that can help them in terms of their growth here on this campus as a student and as an individual. Then restorative justice is kind of a hot term that you're hearing right now, but it's very popular. The outcomes for students are great. But in terms, what that means is restoring if there's been a wrong, how can we restore? And justice, how can we make this right? So it's like a more robust type of mediation, but really seeking to solve or fix the harm that has been occurred. And then that, restorative justice can be a restorative justice circle where those who are impacted, not just the survivor or the victim, are there, and they talk about how this act impacted them, impacted the community. And then the accused is there as well. The respondent can be there, it has to be there, to talk about how their act impacted the other party. So we've used these techniques. We have individuals in our office who are trained to facilitate informal resolutions, and they're actually a fantastic options for a lot of our students who are going through the process.
Great, thank you, Kevin. Just one thing, it is not permitted for cases where a student accuses an employee of harassment or assault under the new rules. So on the Title IX side. And also, you know, if someone were to come to student conduct and say, I definitely, you know, would like to opt for mediation instead of going through that investigation, which could take a lot longer. Both parties have to agree to it, of course, and the university would have to agree that it's appropriate as well. LaShawn, do you think this will be something that survivors may opt for? And if so, how come?
Yeah, I think that some survivors might opt for this opportunity to go through an informal resolution or restorative justice. There may be a few different reasons. It may be the type of circumstance or relationship they have with the individual who harmed them. Maybe they're more interested in this individual knowing about the harm that they've caused, changing their behavior, and just having more of a conversation. In some cases, some survivors really want the individual to know the impact that their behavior has had on them. And so going through this type of informal resolution process might create an opportunity for those types of conversations. In addition to that, for some survivors, they really just want a speedier outcome. They really just want to, you know, make sure the person knows this happened. It's not okay. I want you to hear how this has impacted me. And they're not really wanting something to go on anyone's record or have any other type of outcome other than really restoring within that community. Oftentimes for some people, it's also just less time commitment, you know, and involvement. We're talking about issues that at times can be criminal and or civil proceedings that a student might be choosing to go through. And so the on-campus adjudication process may not be the only process or system that that survivor is managing and navigating. Oftentimes our advocates are supporting individuals who are working with the district attorney's office and or law enforcement, and they are managing and going through those processes that an on-campus option like this might be more feasible considering the amount of time and effort that they're having to invest in the criminal and or civil case that they may have ongoing. In addition to that, there's also challenges as to why some survivors might not choose this option. And these are just a few that I'm naming. Certainly every individual, there's no right or wrong. You know, whatever decision someone makes, it's going to be really important that it's their decision. And that is the role that the advocate plays, is to really support in that, exploring those options, explaining their rights, explaining any concerns or hesitations to ensure that they are in a place to make that informed decision for themselves. But for some, this might not be the best option. It might not feel like the person will really be held accountable. You know, what accountability looks like for some communities and or individuals can vary. And for some people, this may feel like this is not justice for me. So going through a formal process might be a better option for someone, or not going through any process at all. In addition to that, for some, the commitment, you know, might be something that might make them, you know, step back through this, and also just discussing their situation, going through a potential hearing, you know, can be challenging. So, you know, I think that the informal resolution could be a good option for some, and for others, it may not. And I think that the resources we have in sexual violence response can support in those processes, in addition to the resources available in student conduct and community standards. Students do and will have access to a case manager who can also explain, you know, what would be involved and invested in these different systems. Margie, I want to back up just a little bit, because as you were discussing earlier about the different accommodations and resources that are available to students, I just want to also name, as you said, yes, students do not have to file a complaint in order to access those accommodations. Additionally, if a student is interested in working with SVR, if you are a survivor and are wanting accommodations, maybe you are not feeling safe in the location that you're in and you're needing assistance in managing that, Maybe you believe that you need an order of protection. SVR is a resource for that. So SVR is one of the designated locations in the state of New York who can facilitate what is called online remote temporary orders of protection. So we can facilitate this online. If you are in the New York City area, you can come to our office and we can facilitate it directly from the office if that is something that you're exploring. So there's also these accommodations and resources and options that the SVR team can be available to you for.
That's great. Thank you so much, LaShawn. That's amazing. And I would just like to reinforce that at the end of an informal resolution, there could be an agreement between the complainant and respondent, that one person stays away, that the respondent stays away from the complainant, that there's a no contact directive in place. And there may not be any formal sanction like there would be at the end of an investigation and adjudication, but there can still be an agreement between both of them. So this is something that is, a popular option across the country. But as LaShawn pointed out, there are other people who really want an investigation with, a sanction at the end of it. So those are the two options available. Next slide, please. LaShawn, and is there anything else that you'd like to say about the impact of these new regulations on those who may wish to follow a report, or anything more? You certainly described in depth about how SVR can assist students from the beginning to the end of this process. Is there anything else that you could suggest that you may be able to provide, and what would that conversation with the survivor maybe look like?
Yeah, so I think to start with the first part to your question, certainly there are ways that SVR can not only assist and be available, but also really, sit with someone who's going through the challenging and difficult circumstance of having to feel the pressure and potentially responsibility of managing a situation where someone has facilitated, or maybe a community of people have facilitated harm against them, right? So there's these options, there's these resources, there's the rights, and there's just the realities of the impact of the harm, of the trauma. What does it mean to now live with this harm or trauma in their lives? So there's so many additional factors that impacts and informs how a survivor might engage or not engage in utilizing SVR, utilizing any of these resources and options that we're discussing. So I think it's also really important that we just name in this forum that we are talking about harm. And as a community, as Joseph said earlier, it is so important that we all take responsibility, that we all are thinking about our own behaviors, our own opportunities to be disrupting these behaviors. When someone discloses to us that we believe them, that we support them, that we connect them to the appropriate people and resources, that we don't just further participate and or create environments that foster and support these behaviors. So, to me, this is, the conversation can look like a lot of different things. So for some students who contact SVR, they might call our helpline in the middle of the night, and they're really wanting to process what happened to them. So that might be what we call crisis intervention. So that process of crisis intervention and providing that information, listening, validation of whatever they're feeling in that moment, and wanting to just express what happened to them. Maybe they're in this moment of really needing what we would describe as supportive counseling. And so those are just some of the components, but what each conversation looks like really depends on how the individual presents to the advocate that they first make contact with, what they are telling us they need in that moment. It's really important that as a team, as advocates, that we're really giving the survivor, not even giving, excuse me, let me take a step back, that they are, owning, and that they are really guiding us as to what their needs are, that we're not telling them what to do or how to do it, but that we are informing them of their rights and options. For individuals who are thinking about reporting, there might be some individuals who are watching and listening to this forum right now and have had these experiences, or supporting someone who's had an experience. It's really important to get all the information, about what it means to participate in these processes, what rights you have in the state of New York. If you're in a different location, if you're in a different state or another country, getting that information. These are things that, again, that your SVR advocate can assist with and help in aiding and doing the research and gathering that information for you. So I think that, are some of the key pieces that I want to ensure is, that we name throughout this forum. Are there, Margie, did I answer all of your questions, or is there some other components?
Thank you. That's
Great.
great. And just to wrap up, Kevin and LaShawn, can you just very briefly address before we go to questions, how do things differ in, with respect to Title IX in the remote world? Kevin, you want to just start and talk about the hearing? And LaShawn, you mentioned some of the components of Title IX in a remote world, but anything else you'd want to add? Because that's where we are right now.
Yeah, thank you, Margie. So really quickly, of course, we're in a remote world. Obviously, we're doing this via Zoom. We also do our hearings via Zoom as well. And what we have found that a lot of our students on both sides, complainants and respondents, they've actually been very comfortable with this format. They're adept at the technology. We have a whole operations team there to support students. We have students in breakout rooms with their advisors. We have that for both sides. The hearing panel, a hearing officer has their own breakout rooms. We're able to control the timing, the atmosphere. So it's all just virtual. Even when we return to campus, there's a virtual component to our hearing. So we'll have students in one part of campus on video and in another party on another part of campus on video, just to ensure that there's no crossing of paths and that folks aren't triggered by that experience. So the virtual hearings have really been smooth. We've actually had some already, and people have been able to come through, share their stories and witnesses and evidence very smoothly without any issue.
Okay, thank you. LaShawn, anything new?
So yes, there is definitely some new structures in how students can access an SVR advocate right now. So we are on site. So for those of you who are in New York City, you can access the Sexual Violence Response Office. If you're at the Morningside campus, we're in Learner 700 Monday through Friday, 9 a.m. to 6 p.m. If you are at the medical campus, that location is open 2 days out of the week from 9 to 5. And in addition to that, we do provide virtual appointments. So we're able to do same-day appointments with students virtually. So if that's just a preferred method and or you're out of state or out of the country, that's one method, and we do that through Zoom. In addition to utilizing our helpline phone system, which we're able to provide services over the phone. And again, supportive counseling and information throughout these processes. For a student who's going through a virtual hearing, who's again in the local area, if they were looking for a private space in order to participate in any interviews or any kind of interaction that they're having to go through in partnership with Title IX and or student conduct and community standards, they can work with their advocate and utilize a private space that we can make available in the SVR suite. So that is an option. It's definitely something that would need to be coordinated in advance. But if that is a concern for some people, because there's some advantages to being able to do these hearings and participate in working with an advocate from any location. However, we also recognize that for some people, you may have people in your living space that don't know that you've gone through this, or that you're participating in a hearing process, or that you're a witness in a hearing process. So for survivors who would be complainants in this process, can coordinate with their advocate to help in identifying a private location in order to participate in these proceedings.
Great. Joseph, can we go to some questions for the panel?
That would be great. First of all, thank you so much for all this wonderful information and sharing all the wonderful resources and care that you're doing for our students through our processes. We have a few questions here. So I'll start with, are staff and faculty mandated reporters for the new Title IX regulations and the gender-based misconduct policy at Colombia?
Yes, our mandated reporter program, where any student-facing staff person must report, any kind of sexual assault, sexual harassment, dating violence, domestic violence, stalking, sexual exploitation, or discrimination in general must be reported either way. And so, you know, the faculty member who hears that a person has been sexually assaulted and needs extra time must make a report, but he or she or they will not be deciding which policy it will go into. That'll be decided later on by staff. So thank you, Joseph.
Thank you. The next question comes wondering, what are the gains from the Trump DeVos to narrow the Title IX definitions?
What are the gains?
The gains. They put this in quote.
Okay, you know, there were, as I said earlier, 125,000 institutions, individuals, people who commented on these regulations. And I think that, you know, there are a lot of people who felt that there was not enough due process in these hearings for those who were accused. And with the addition of cross-examination, of course, that's an additional due process, you know, quality that has come to these hearings. In terms of narrowing the definitions, I would say that the gains to institutions that, you know, don't want to handle all these cases and want to say to their students, you know, we don't have to do these cases. You go to the police or go to a civil lawyer. I guess it would be a gain to them. We have chosen not to you know, take that, you know, what some might consider an advantage because we feel like we could not protect our environment of sexual respect if we, you know, said we're not going to deal with any of those issues.
Okay, thank you. We have 4 more. I know we're getting close to time, but I think it's important to get answers for our students and to be able to share that. So if you all can stay with us for a little bit. So LaShawn mentioned this process going on their record. What are the policies and procedures governing the documentation of the conclusion of these investigations? And for how long are they retained?
The documentation, Kevin, you want to answer that one?
Yeah, so there's a number of things that can go on a student's record. And when we say we have a conduct record, and there are things that go on students' transcripts, right? So suspensions, expulsions, all these things can go on a student's transcript. If a student is found responsible for sexual assault, they may very well be expelled. And that is on a student's transcript, right? So that can follow a student in terms of if they're applying to graduate school, professional schools, they have to report that. A lot of schools will ask, employers will ask, provide us with your transcript, and then they see that notation that you have a conduct record. They will have to explain for many years, right? It depends, but for many years that you've had a conduct violation, and in that student's status may be in jeopardy in terms of them getting employment, or it may be in jeopardy in terms of them gaining admission into a program. So there's a litany of options that's if someone is found responsible, whether it's probation, whether it's suspension from the university for a period of time, and then expulsion, which can be on the transcript forever.
I'd just like to add to that, New York is one of 3 states, including I think Virginia and Texas, which require transcript notifications if there's suspension, if someone is expelled, or if they withdraw in the middle of the process. Now, Colombia has an appeal for that, but the transcript notification has to be on the transcript for a year before somebody can appeal to have it taken off. And the university will decide whether that is an appropriate disposition. The records as a whole, I think, have to be kept for 7 years, but those are not necessarily shared.
And the appeals process for that notation goes through our office, and we work with the dean of that student's college to get full context and decide whether or not a notation should be removed or not.
Thank you. We have 3 more. So if there was a pattern of abuse by a faculty member, can multiple individuals submit a complaint together?
Yes, they could, they would be interviewed. Anybody who wanted to be a complainant, in other words, a party in the case, could be a party in the case. And if it was a pattern of, and it was severe and pervasive and objectively offensive, it would fall into that Title IX chute. And each of those people who wanted to be a complainant would have an advisor appointed for them to consult with them. If, let's say, 5 of them wanted to just be witnesses, or 4 of them wanted not to participate, the university could still go forward in such a case with the people who wish to participate. And as I said, those people would have the opportunity to have an attorney advisor advise them. But at the end of the day, Joseph, as we said earlier, it's always is complainant driven. It's always up to the complainant whether or not they want to participate or not.
Thank you. And then what is the role of the ombuds in Title IX?
LaShawn or Kevin, you want to answer that one?
LaShawn?
Sure. So the Ombuds Office is a confidential resource. So if someone disclosed any of these behaviors to the Ombudsman, that would not be reported. So certainly discussing the situation or the matter likely will receive some referrals and resources through the Ombuds Office, and also potentially, again, exploring what rights and options are available to the individual who speaks with them. But Kevin, I don't know if you want to add anything further.
I think it's important just to add that we partner with all of these offices. So whether it's EEOAA, SVR, or the ombuds, so don't worry about where you're submitting reports. We all review all those reports, and we can facilitate our operations teams. We can facilitate the different offices. If it's a faculty member, that's an issue, or a staff member, we can send that over to EEOAA. Ombuds persons, we can facilitate those as well. So we work with these offices. So I wouldn't get caught up with the distinctions as much. We partner and we all communicate and we talk.
Great, thank you. Next question, are hearings recorded on Zoom? And there's a subsequent question. Zoom gathers data of every Zoom activity. How is the student's data privacy protected, or are they informed of this data sharing possibilities?
Yeah, so we do record the hearings, and that's for our internal records purposes. Students can request that if they're trying to formulate their appeal or anything like that. Even when we're physically on campus, we're using video technology. We're recording that. Students on both sides can request that. And that is for students who have a record. There's transparency. Students who want to formulate their appeal and they want to look at how a student responded or responded to a question. We find that to be very helpful. We have an operations team that's very skilled in making sure that if there's any data or metadata that's wiped after a certain time period. But in terms of that being a part of that record, we keep that as long as the case is in duration and being adjudicated.
Great, thank you. And then, and for those in the audience, I'm going to have the panelists answer our last 2 questions, but at this point, given the timing, we're not going to take any others. And but the last 2 questions. So one is centered around while your office, and I think this is LaShawn with SVR, is appropriately focused on supporting the trauma experienced by the complainant in these cases. Has your office also considered the trauma experienced by the respondent in these cases, regardless of the outcome? And maybe that's a question to you also, to Kevin, regarding the case managers and the roles of those professionals in supporting all parties that go through a process.
Mm-hmm.
Yeah, so I'll respond to the piece regarding sexual violence response. So certainly we are a resource that is directed towards working with students who identify as survivors and or in this process as complainants. And certainly, the work that we do, particularly on our prevention side of the work, it is really important that we consider and really think about the traumas happening across the board. So everyone involved. Trauma is not unique to only individuals who experience the harm, but it's also anyone who's actively engaging in causing harm against others. There may be trauma there. The impact on the community that may have witnessed or is familiar or aware of that harm. So much of the work in SVR, particularly around the prevention and education components, we are really thinking about the entire community and all individuals involved. However, our direct services and the work that we do with survivors is dedicated to that population and is informed not only through our training and the work that we do through the university, but also through our certifications that we hold with the state of New York and federal regulations that support our organization and programs. So we do work closely with our partners on campus in thinking through strategies. We do joint trainings together to really think about how are we best supporting individuals who may be identified as respondents and experiencing harm or trauma as a result of these experiences. And I just want to also name that there are moments where we are working with, and I say we in sexual violence response, individuals who have disclosed experiencing ongoing abuse in their relationships and later learned that their partner has filed a complaint against them. So they may be named as a respondent in a situation and they've been dealing with some ongoing trauma and working with an advocate and or some other resource in a confidential capacity regarding that issue for a period of time. So there's a lot of different ways that we try to think about this. It's complicated. There is no, set way of approaching it. However, I do want to be clear, SVR is a resource for survivors. And in our prevention work, we create spaces and opportunities for all of us to discuss as community members what accountability looks like, what the impact of these behaviors look like, and how do we support everyone through the process and what those measures might what might need to take place, and support the community in building their capacity and their skill level and appropriately having those conversations with individuals who may be respondents or individuals who are causing harm.
Also, just to add one thing, supportive measures are available for both respondents and complainants. Now, here at Columbia, we have always done that. The new regulations require that. And so if a supportive measure, for example, a move, an academic accommodation, because a respondent is going through something like, an investigation or a hearing, the case manager will work with their advisor to provide academic and other accommodations as well, and connections to counseling and psychological services for the emotional support that students need for that sort of thing. Kevin, do you have anything else to add?
Yeah, thank you for that pitch. The case managers are actually very helpful. They help both sides. And what's important for students to remember, I really want to stress this, that your case manager is with you for the duration of your time, right? So students oftentimes forget that case is not just when your case ends, we can continue to assist you throughout your time at Columbia. So whether that's accommodations, if you're having issues, connecting you, I see case managers as connectors, right? Connecting you to different resources on campus that can help you get through your journey here at Columbia.
Great. And then one last question. And then if others have questions, I know there's a few others trickling in. I apologize, we're already over time. You can email your questions to universitylife@columbia.edu and we'll get some answers for you for your specific question. But the last question is talking about under what circumstances would a Title IX complaint be disclosed to a prospect employer? And i.e. a prospect employer requests whether or not a complaint exists for an applicant.
A complaint itself would probably be unlikely to be disclosed, particularly if it wasn't an adjudicated case that was over. Many employers answer questions like that with just giving the dates of employment for someone. But I would say that most jobs require one to answer questions in an employment application that would cause such a case to be revealed. So there are some pretty strict rules on disclosure that do not mirror those that are in place for transcript notifications. But it usually ends up happening that a question to an answer, if it is truthful, may lead somebody to have to disclose that kind of thing about their own experience at the university. If a question is asked on, to a reference, for example, where, is this person subject to, or were they found responsible? Of course, we would have to, answer honestly, of course.
I think also, just to piggyback on Margie's comment really quickly, I think, you have to be careful when you're applying to graduate or law programs. Oftentimes they may ask if a student has ever even been accused of a student conduct violation, academic integrity, or sexual assault. So depending on how the question is worded, you have to be careful. Oftentimes if you've been found responsible or if you've been confused. So some schools or some professions may have a really broad kind of avenue for that question.
Right, and if there's assistance needed to answer, for example, if someone was found not responsible and they applied to law school and that question is asked on lots of law school applications, they could certainly refer them to someone over at Student Conduct to say this was a long investigation and the person was found not responsible for this behavior. So it's another layer of information for the school that the person wants to go to. And I know that that's happened.
Well, I want to thank everyone for there's 70% of our audience has stayed with us past the time, because this is such an important topic, and it's so important that we have sexual respect across the entire campus community. So I want to thank all of our audience for your active participation. I want to give such gratitude to our panelists, not only for sharing your expertise in this space, but for the care and thought that went into, and the extraordinary work that went into looking at our policies and procedures when the federal guidelines came to us in the summer and giving us really only the summertime in order to really evaluate and to do this in the best way we can as a Columbia community dedicated to sexual respect. And at a time that COVID-19 was happening, at a time when anti-Black racism is across our nation, I just want to give such gratitude to all of you for your work, your dedication to our students, the student experience, and to sexual respect at Columbia. And again, if you have questions that didn't get answered, please feel free to email us at universitylife@columbia.edu. And again, thank you for being supportive and being a community member, and to making sure that we focus on prevention always and stepping in where needed to create sexual respect at Columbia. Thank you, everyone.
Thank you. Thanks for coming.